Hi, Attorney Carlos Colombo, and today we have a special guest, one of our senior attorneys, Anthony DeLucia. Anthony, welcome.
Absolutely. Thank you. Glad to be here. Glad to be here.
And Anthony and I both have Italian last names, so you have two Italian guys uh, that are going to be informing you on a very important topic today, which is how to prove national interest when you're applying for an EB-2 National Interest Waiver application. Um, Anthony, if you want to maybe give a little bit of brief. We're not going to get into the details on how to qualify for an EB-2 NIW, but maybe for those folks that don't understand what an EB-2 NIW is, if you can give sort of a brief introduction.
Sure, absolutely. So an EB-2 NIW is a second preference class visa. Essentially, what it means is that so long as you have, as at a minimum, a bachelor's degree and 5 years of experience, and you intend to work in a professional capacity in the United States, you are otherwise eligible for this visa. However, unlike something like a perm, it does have an additional qualification of a precedent case called the Danisar decision that outlines three specific prongs that an individual must meet. Those being whether or not the proposed endeavor is nationally important or national in the national interest of the United States, and it holds substantial merit. Number two, whether or not an individual is well positioned to advance the proposed endeavor in the United States. And then three, on balance, whether or not it is in the benefit of the United States to approve that particular visa from a very simplistic side of things. What I tend to focus on is the legal strategy of how to approach these particular prongs in the light and milieu of what USCIS wants on any given day. That's sort of what I focus on more.
Right. So one of the advantages of the NIW, because it is that waiver of
Hmm.
the job offer essentially and going through the perm process, is that you're self-petitioning, right? You don't need a company
Absolutely.
to come in and sponsor you, which it's fairly difficult nowadays because of different factors, including the fact that perm takes much longer. It's a much more complicated and expensive process, and the company's controlling that application, but also paying for it. So, NIWs have grown in popularity, especially in the last 3 or 4 years. They continue to be probably the best option for high skilled immigrants are looking to obtain a green card. And Anthony and I may use the term visa because that's just commonly used. But remember that the EB-2 NIW is an application that leads directly to a green card or U.S. permanent residency. Um, so, out of those topics, those requirements that we just went over briefly, national importance or national interest. Is really where most people get a little bit perhaps confused. I've even seen a lot of attorneys that maybe are not as experienced, not fully understanding how it is that you can prove that what your endeavor is, what you're coming to do to the US, could be of national importance. Um, and based on what immigration, what USCIS likes to see. So, Anthony, if we can get into perhaps you can break it down. I always like lists maybe of three of the topics that we can
Sure.
cover. How do you prove national importance and what should you look out for?
Absolutely. So, national importance is one of the more difficult topics to address when it comes to the NIW because, in and of itself, it's one of the more inherently subjective elements that an officer has to assess when they're looking at whether or not an individual should or should not be approved for an NIW. Because it is more subjective, inherently it means that that officer is vested with a lot more discretion in making the decision as to whether or not an individual meets that prong. The Danisar decision does outline several potential factors that may be helpful or probative in proving the national importance of a particular proposed endeavor. But really, from my perspective, what I've seen in my practice here at Colombo and Hurd over the last few months, the trends are suggesting that the three bigger topics that USCIS is focused on is number one, for an individual who is going to be self-employed or is going to be engendering their endeavor in the United States in a non-direct employment capacity, is the economics of the endeavor. What are the economics? What is the benefit to the United States from an economic standpoint that would otherwise prove the national importance of the endeavor? So economics is number one. Number two is the scope of the endeavor. How far-reaching is this endeavor going to be? And if it's more localized in nature, what is the scope within that localized milieu that's going to provide that inherent benefit? And lastly, but certainly not least, how you utilize this comparative evidence that you need to demonstrate national importance in order to meet the more arbitrarily sometimes set threshold of USCIS officers.
Right. So, yes, I mean, there is always a subjective portion to any visa application or green card application, right? Officers always have discretion, not only in the
Sure.
EB-2 NIW, but in any application for an immigration benefit. There's always some level of discretion that the officers have, but there's also regulations, laws, and certain parameters that they have to follow. And one of them,
Yeah.
as you pointed out, is the Danisar decision. The Danisar decision, it provides a framework for officers, but USCIS also has a little bit of wiggle room in how they interpret that decision. And we've seen some shifts. Sometimes maybe the one administration, the first Trump administration, seemed to be fairly open and flexible with Danisar. Biden then came along and prioritized certain things over others. And now we have the second Trump administration. So if we start with number one on the economics, because let's remember, even under Danisar, those are just examples. It's not an exhaustive list of how you can prove national importance, right? Those are just some examples, but we see that a lot of the times officers want to see what is the economic impact that your proposal or your endeavor can have in the US. So let's dig into a little bit deeper on that. What does that mean? What are they looking for from an economic point of view?
Sure. So the Danisar decision specifically states that from an economic standpoint, whether or not an individual as a potential factor to meet demonstrates a significant potential to employ U.S. workers or otherwise offers substantially positive economic effects or benefits to the United States, particularly in an economically disadvantaged area. Now, what that truly breaks down to is, from a plain reading of it, do you have a good chance of employing U.S. individuals, or otherwise do you offer really good economic benefits to the area that you seek to pursue your endeavor in? And if that area happens to be a enumerated economically disadvantaged area, you get a little bit of a bonus point on that front from the USCIS and from Danisar's decision. So really, that's the only truly enumerated economic side of it in the Danisar decision when you look at the plain language of it.
Right. Now, a lot of clients are going to say, well, but I'm not planning on creating the next Apple or Microsoft with thousands of jobs. I mean, does it have to be at that level, or can it be something perhaps a little bit more local impact that then can translate into potentially something bigger?
You don't have to be the next Jeff Bezos when you come to the United States. That's simply untrue. And certainly if the Danisar decision were to ever have enumerated that you have to employ tens of thousands of individuals, it wouldn't have passed muster. The reality is that the specific language utilized in the Danisar decision is focused on the potential to employ U.S. workers. It does not set some arbitrarily enumerated number of people that you must hire. It doesn't say that you need to have 10, 15, 20 employees. All it focuses on is what is the substantial or significant potential to employ U.S. workers? What is the forecasting that we can reasonably say that you are going to have any employees at all? And that's where the focus should lay, not only from the legal side as an attorney, but from the officer adjudicating it as well.
Right. And a lot of the times it may be that, you have an innovative idea that can help generate jobs. It perhaps has a local impact at first, but then you can show through a plan that could be translated at the national level as well down the road. And in fact, Danisar even gets into some of those details that national importance doesn't mean that you must immediately come and have a business that is nationwide, because that's a lot of the times that's how folks see it.
Mhm.
So it could be that local impact that then translates at a more national level.
100%. And the Danisar decision actually does us a favor as attorneys and contemplates this. In overturning the prior precedent decision, which is New York State Department of Transportation, they explicitly state that the new generalized criteria is no longer focused on scope in terms of breadth or geographic reach. Even more localized endeavors may be well understood to have national importance, so long as they fit into what are otherwise enumerated national initiatives, or the benefits that they bring to those localities do still pass muster with the remainder of the assessment. So they did away with this notion of geographic reach matters. They did away with that expressly in the Danisar decision.
Excellent. All right. So let's move to point number 2.
hmm Which is a beautiful segue, quite honestly, because it actually relates directly to scope. This notion that, yes, localized endeavors may have national importance. You don't need to go into the NIW process believing, as we discussed, that you need to be the next Amazon, or your endeavor, your company is going to have a multi-billion-dollar bottom line. The reality is that Dr. Danisar, the subject of the precedent decision, didn't generate a single job. He did not generate a single dollar of profit for the United States. Now, granted, his endeavor was different. He was an academic researcher. But the point remains salient that if an individual who did not provide any sort of material economic benefits at all to the United States can get an approval, then the reality is that individuals who have endeavors that are more localized, say sole proprietors, things of that nature, who would otherwise offer the locality that they move to a fairly significant benefit, generate a couple jobs for that area, help boost up that local economy, that's well understood to have national importance, even in light of what the language of the Danisar decision states.
Right. And that actually shows you that all of this is an interplay of the same thing at the end of the day, right?
Right.
You're not going to really, you're not going to differentiate one thing from the other, because at the end of the day, what you're trying to prove is your individual contribution. And the NIWs are very individual. There's not a template that you can apply to a case that will work for everyone, or even within a certain industry. It's very particular, it's very individual. So that scope may be on one side big for certain applicants, or it may be much more local or smaller in some other applications. So that's where we come in as the experts to help you based on your background and based on what you are proposing to do, to understand what immigration wants to see in your application. And Anthony, as an expert, senior attorney here at Colombo and Hurd, that's what he does every day, is trying to guide those clients in understanding these intricacies. Because at the end of the day, Anthony, I mean, you and I do this every day, and it's a lot of legal jargon and expressions that folks that are not doing this, that are not experts, may not understand. But at the end of the day, there's not a typical NIW case.
There really isn't. I mean, and even if you look, like you said, across the strata of the same field, what individuals may be doing specifically to them still can be demonstrated as national importance. That's what really matters, is relying upon us because we have the experience. We're here to help. That is ultimately what our goal is to look at an individual situation and go, how can we best represent this individual? How can we best demonstrate everything? And it's also important to remember that when it comes to things like national importance, as we said at the beginning, it's a multi-factor assessment. You do not have to hit every single factor of every single facet of every single prong. It is a better than 50% chance. And although we tend to definitely exceed that, you need to rely on us sometimes as the attorneys. That's what we are here for. We're here to help. And I definitely focus on that in my practice. And I help as many people as I can, throughout the firm to certainly find those avenues to reach that ultimate end goal.
Right. The better than 50%, you mean because you have to more likely than not prove. It's not a clear and convincing standard like we say in the legal
No,
world. It's just a
no,
little bit
or
more evidence that more likely that you're going to win. That's
right.
what immigration needs to prove.
Exactly. For individuals who aren't familiarized too much with the legal arena, most people see it through TV or movies where everything has to be beyond a reasonable doubt, that everything is in the criminal milieu. The reality when it comes to these NIWs is that it's on this balancing test, right? Is there a better than 50% chance that you meet these requirements? And generally speaking, the answer is yes for individuals who are otherwise eligible. That's generally speaking what the answer is. Sometimes there is a little more argumentation that needs to be made, certainly, and that's where we come in as attorneys to work hard to represent individuals to the best of our capacity.
Right. And so there, that's a great point to come up to the final point that you had on point number 3 is the type of evidence and what you're going to be submitting to immigration, basically.
Absolutely. So when it comes to, as we just discussed, this concept of if an individual has maybe a more localized endeavor, that's totally fine and maybe well understood to have national importance. But when you provide that, the national importance may not be as evident as, say, someone who comes to the United States with a multi-million, multi-billion dollar company from an economic standpoint. So, where we come in then as attorneys is gathering the comparable or comparative evidence to prove that this particular entity or individual still passes muster. I'll give a brief example. The standard, as we said, is whether or not an individual offers substantially positive economic effects, particularly to an economically disadvantaged region. Well, looking at just that, we have to ferret out whether or not that region is an economically depressed area. That requires objective evidence to prove that this particular area meets the federal definition of an economically depressed area. Then you have to address what is substantially positive economic effects. USCIS unfortunately did us no favors by not saying what that is, but thankfully, with the benefit of experience and time, we understand what that more means. So, providing things like evidence of what the average income of a business is in that particular area, what kind of net profits are they going to bring, and what kind of tax benefits are they going to bring to the area, all is beneficial evidence that should be demonstrated that may not necessarily be required for a larger endeavor, but still manifests as national importance regardless of the size.
Excellent. Yeah, and that's one thing that, I always emphasize with clients is we have the advantage that these applications are in writing. This is not a trial or an interview where Anthony and yourself as the client are going to go in and have to prove, like you said, beyond a reasonable doubt that you're going to win. It is in writing, and you have to provide evidence that supports these arguments. So that is going to be the team effort. That's the way that we do things here at Colombo and Hurd is collaborating with the client to make sure that we can gather the best evidence we can to present your case, help you through that process, and understanding the recent trends. Because, like Anthony also said, is sometimes immigration moves the goalposts a little bit on how they interpret these regulations, or in this situation, the case of Danasar, which provides a basic framework. Those officers do have some subjectivity. And now also keep in mind that these are just some examples. What we've covered today is some examples of how you can prove national importance and some of the recent trends that we see. It's not the only way you can prove it. Anthony and I will do more videos on other ways, perhaps in different types of NIW cases, on how you can prove national importance. But I think, Anthony, we highlighted today the 3 most common issues that we see with national importance and how to win those cases. As always, it's always a pleasure. Anthony, thank you so much for your guidance today.
Absolutely, my pleasure. Always a great time to talk and discuss all of this, and happy to share as often as I can.
Thank you.
Absolutely.